Mining companies no longer have the power to throw people from their homes. Thursday's historic Constitutional Court ruling is giving landowners their power back. Residents from the Letsitleng community in the northwest were forced off their land by two mining companies. The ruling will see communities return home. ENCA's Aaron Bates has the story.
The Constitutional Court has affirmed informal land rights in a landmark decision. It potentially affects up to 17 million people living in what were previously called homelands. Letsitleng community members challenged a High Court order permitting their eviction from Modimo Malo. They won.
All the mining companies, they must consult with the owner. If your ownership is not that clear in terms of the previous laws of apartheid, and you haven't managed to do the title deed adjustment, then they must consult with the lawful occupiers like ourselves. In this case, the judge said we are lawful occupiers, and if you are not a lawful occupier, they must consult with the interested parties.
Sekhatla culture is very democratic, where there must be consultation. And if I can tell you, where the Khosi realizes that his decisions are against or do not have the support of the tribe, he will have to join the tribe, rather than to push his own interests alone.
On my own, I will say I will want to see substantial shareholding being given to the Letsitleng community. The Deputy Minister of Mineral Resource, Oliphant, Godfrey Oliphant, was here a month ago, if not two. We told him here that we want 51% shares.
The judgment is a game changer for other communities too. A land researcher claims government and mining houses, working with traditional leaders, have ignored residents' informal land rights.
The leaders get paid off and the people are unable to hold them to account. Yet legally, traditional leaders do not have the authority to sign such deals. Only the Minister of Rural Development and Land Affairs has that authority as the nominal owner of the land, and he or she is bound to obtain the consent of the people whose land rights are affected in terms of the Interim Protection of Informal Land Rights Act. That is what this judgment reaffirms.
Letsitleng's traditional council member and finance chair has this advice for others.
First of all, they must unite. Unity is the power. And secondly, they must gather information, relevant information for themselves. And they must know their rights. And they must protect their rights.
An attorney working on a similar case in Xolobeni, Eastern Cape, has taken note.
As with Letsitleng in Xolobeni, the Nkosi, the chief, is a director of the mining company that seeks the mining rights over the community's land. And that, as we've said, is a very common practice. And what this Constitutional Court judgment means is, fine, it doesn't prohibit that, but it doesn't mean that you get the land rights automatically by striking deals with traditional leaders.
Minister of Mineral Resources, Gwede Mantashe, has welcomed the judgment. Aaron Bates, Letsitleng in the northwest.
Let's get some more digging into this right now. I got with me Blessings Ramoba from the Mining Forum of South Africa, Tebela Chibane from Minerals Council South Africa, and Johan Lorenzen from Richard Spoor Attorneys joins us from our Cape Town studios. Welcome all three of you. Blessings.
Thank you.
This must be good news.
Yes, it's what we've been chatting.
What an impact.
We welcome the judgment. It's a good step in the right direction. So it's about the land. Our people have been evicted out of their land illegally. Therefore, the same method that which was used during the apartheid time was applied in 2004 when these people were evicted illegally. Therefore, what we are calling on the public is that they must study this constitutional decision, and it's going to help mining communities going forward.
Johan, tell us about your role and how you believe this came to the conclusion that we're talking about right now.
Well, I believe this fundamentally changes the game as it relates between communities and companies. As our clients in Xolobeni face down a multinational mining company, the fact that the Constitutional Court has held that no mining can commence until compensation is determined in advance and consent is granted by the community or there's an expropriation, totally changes the default practice, which until now has been the mining companies start mining and they negotiate along the way, in effect, constructively evicting people and forcing them into outrageous agreements that are prejudicial to communities.
I mean, staggering that it's taken so long and that something was considered a fair practice.
That's exactly right. And it's what I think is really important. We just heard the ministers welcome the decision. This just is common sense. It cannot be 25 years into democracy in South Africa that communities continue to face the same dispossession they faced under colonialism and apartheid. And that is what this judgment puts us on track to end.
What is your response? What sort of impact do you think it'll have on mining communities?
Yeah, good evening. I really do think the Minerals Council also welcomes the decision. I think it's actually quite key in that this judgment is basically reinforcing what the law says in terms of this IPULRA, okay? So especially with those that have informal rights or unsecured rights in land, I think it is actually quite a critical decision in that the court is basically saying you do have those rights and so your consent must be sought before you are removed from property. So I think it is actually quite an important judgment. And I think, look, I mean, in the normal course of business, mining companies have to negotiate with landowners in order to gain access to the land. And so it's a negotiation process. It happens in thousands of other mining rights, either in traditional or non-traditional areas. So it was important.
Possibly your traditional kind of negotiation process. And I'm just wondering what what you all stand for when it comes to these sort of conversations between mines and communities. Were they aware? Did you make them aware of what the implications were?
I think the companies are certainly aware. Remember, look, this is a portion, this judgment doesn't apply to instances where there's different types of tenure, for instance, where people have title deeds. It hasn't actually changed that element of the law. It's dealing more, I think, with your more vulnerable communities that had those informal rights. And I think you're absolutely right. It was important that this issue was actually clarified and given, so those communities are certainly given a strong, much stronger position with their right to consent. So, I mean, look, what do we do as the Minerals Council? I mean, certainly, we try to show that our members comply with the law. And, we've even got a membership compact that essentially started in 2015, where we want our members to do the right thing. It's a code of good business practice, and adherence to the laws is certainly one of those key things also within that code of.
And where's the Mineral Forum being in?
As the Mining Forum of South Africa, we've done a study over these social and labor plans, over the mining charter, over the MPRDA. Let's speak to this one of this judgment. 80% of the mining companies do not do consultation. In fact, they approach the traditional leaders secretly, so they go and get the signatures. They can call individuals to say, come and sign down. They think that they are getting jobs.
And many community members don't know what they sign.
Yes, when they sign, you must know that they are vulnerable or they are looking for opportunities. Those signatures are used for everything. When they renew the mining rights in the East End, where they are renewing the mining rights, they still use the same signatures. So if now the communities, they become aware of this judgment, I can tell you, 80% of where mining operations are, they are going to challenge these mining companies. So what we are saying is that we do not want to fight with the mining companies as the Mining Forum of South Africa. We stand with the communities. We support the communities. We are saying that mining must be done right. Let there be a consultation. Let there be stakeholder engagement. All the parties should be happy. Now, when coming to this judgment, it speaks to land. Fanon says that all the struggles is about the land, and everyone wants the land. Those individuals were in their land, they peacefully so. This mining company, together with the traditional leader, which is the chief in this particular case, they came, they said, leave the land. we want to mine without their consent. Therefore, this judgment speaks about consultation. Let us do consultation properly, and individuals, including ordinary person who's very much poor within the community, they must be consulted. Therefore,
I mean, sorry, the mining companies, mining industry must have known that this was wrong, just speaking to the community leaders. Some of them which don't have the support of the community, knowing that they were selling them out.
Yeah, look, I disagree with the views of my colleagues that in 80% of the instances there's no consultation. That's not true. I mean, in a lot of instances there is consultation, but it's not that easy.
Proper consultation?
Proper consultation too. Look, I think though it is actually quite a challenge. Remember now, so picture, look at the mining company itself that goes into a particular area. You can't now ignore the traditional leader and start an engagement process with those people that purport to be community leaders. I mean, communities are not homogenous. There's those that purport to be leaders are leaders one day and leaders not the other day. You can't go and essentially consult and try to reach agreement with some person who does not have legitimate authority. Either the person's not a part of the municipality or part of the traditional system. If you do that, you are undermining, the traditional system. However, what we do need, yes, mining companies have often engaged with the traditional leaders as the leaders of those communities. But the big issue is that those traditional leaders are not accountable. There's been the crisis. I mean, look at other countries in the world. There are many other countries in the world where, and I've seen mining companies where they engage with traditional leadership. Those communities are therefore then consulted through traditional leaders, but those traditional leaders are accountable to their people.
And that's probably
key. Accountability.
Let me just jump in here because we've got a caller. Tersha from Edenvale. Go ahead, Tersha.
Hi, good evening, Jane. How are you?
Good evening. Good, thank you. What's your question?
Thank you. Thank you for taking my call. This landmark case has actually given me renewed hope that one day we will actually go back to our great-great-parents' land. The land in question is the land called Grootbaggendrift. And Grootbaggendrift is not far from Bushhoek. It's not far from Bafokeng community. Mm-hmm. I think, I can't remember how many years ago, the late minister who just passed on now actually handed over the land back to the community of Matau, which is very far from the Royal Bafokeng where our parents were moved to. The land that I'm talking about is a very fertile land in a sense that you've got chalets in this community, actually in this land, very good grazing land for our livestock, and actually small-scale farming. Small-scale, what you call mining, that is actually taking place in this farm. Till today, we're still struggling to go back to the land that was actually bought by our great-great-parents. I am so happy about this landmark case.
Okay, well, thank you very much for that. Thank you for that story, Tersha. Let me put that to Johan. I mean, this really opens up an opportunity, I should imagine, for those who've been affected, the hundreds of thousands, to change the course of their lives now.
I think it provides a fantastic opportunity for people who have already lost land and been faced loss and harm from mining activities, because this makes very clear that when companies sign deals with traditional leaders, in effect, it's not worth the paper it's written on if you're not engaging with the directly affected individuals and striking deals, and then going forward with new deals. I appreciate that the Minerals Council is welcoming the judgment and welcoming compliance to the law. I can't say I'm particularly sympathetic to the complications that are being raised. Mining is difficult. Mining is incredibly destructive. And we need a system where we can adequately balance the interests of all the stakeholders. And if that takes engaging with individuals, particularly black people who have faced loss of security of tenure because of apartheid and colonialism, and engaging with these individuals as fully empowered citizens of South Africa, and that becomes difficult, sorry, that's what it takes to profit from their land.
Okay, how do you get that balance?
Now, simple. The balance here should be done in this way. You should consult as a mining right. The person who has got the mining rights has got the rights to mine. And even the communities owning the land, they've got the right to the land and to decide what they want to use with the land. If they don't want mining, let's say maybe they are farming. Therefore, they are going to sit down in that meeting. It must be the majority meeting in terms of the community. 60% and more of the community should sit down in that meeting. They decide their own future. Hence, I said that it's all about the land. They decide whether they want to farm or they want the mine. If they agree both
that's
parties,
what's happening in
yes,
at the moment,
if they agree both parties, they can have a compensation to the land so that they're able to relocate to another state, another place, and they're able to build and be happy. But if they are not reaching a consent, the Department of Mineral Resources is there to mediate. Therefore, in this case, the Department of Mineral Resources failed the communities in that area because they should have mediated, and therefore the situation was not going to be the same. The situation could have been handled better. Since 2004 until today, those people have been evicted illegally so. Therefore, they've been abused. And, you can understand the trauma of these individuals being relocated from wherever they were staying, and therefore there is a mine operating there. An open cast, the land is destroyed as we speak. Therefore, the damage is there. What we are calling for the mining for the mining companies is that let them come and engage with the communities. Because the same community, the same mining companies today, they are in these mining communities. They have got what we call intelligence. They listen and tap the phones of community leaders. So, because they've got a problem, they did not do a consultation. Consultation is important. It deals with the issues of the environment within the mining space. Because their land there is going to be destroyed. And even
destroyed forever. Excuse me, let me jump in here quickly. Victor from the Northern Cape, go ahead.
Hi, can you hear me?
We can hear you clearly.
Jane, thanks for allowing me to give input. I'm staying in Katu in the Northern Cape, or in Dingleton, where the Kumba and Anglo-American iron ore mines is. The problem is actually bigger than just this traditional land where, the traditional leaders are signing off on deals. We are, a town that was resettled to make way for mining, and we are still a few left. We are represented, some of us are represented by Richard Spoor. I think Johan Lorenzo is now aware of this. What currently happened here is actually constructive removal. The mine, while they are still busy negotiating with us, between them and DMR, they manage now to fence us off. You can't even move around now. There's a fence 2 meters away from my house where I can just get out of my gate and drive out of the town. I can't move around. They are mining like whether DMR is aware that the MPRDA makes provision there for mining adjacent to a residential area to have a certain buffer. They are mining like 100, 200 meters from our houses. They are especially mining at night so that we can't take videos and pictures. So in the morning when we wake up, it's dusty all over the place. You need to stay in the house for an hour or two for the dust to settle before you can allow the kids and everybody out.
Wow.
Okay. I don't know how to explain. Johan can maybe explain to you.
Okay, let's hear what Johan has to say. Thank you, Victor. And then I'll come to you after. Go ahead, Johan.
I think Dingleton is a fantastic example of exactly how the status quo has been allowed to persist in the absence of legal oversight. We all are sitting here around the table, including the Minerals Council and the Department of Mineral Resources, saying, of course, communities should have a right to say no and be engaged with regarding mining. While we say these words in light of the Constitutional Court judgment, mining companies continue to mine and make life intolerable while they purport to negotiate with even hands. So while fly rock is landing in the community of Dingleton, for example, here, they're supposed to be negotiating at an arm's length as equal parties, and that is fundamentally not possible while mining is taking place. In the Constitutional Court, I disagree with what was said by the Minerals Council. The Constitutional Court did speak to land beyond customary title. It says it's unclear why, after a dispute is declared under Section 54 on compensation, pending the finalization of this process, a mining rights holder should be entitled to mine. And why? Because how do you have a negotiation on fair compensation while your land is literally being stripped away from underneath you? Okay. And so I think this is a game changer, not just for customary communities, but we look forward to other marginalized communities, such as the community of Dingleton.
Okay, Tebelo?
Yeah. Look, I just want to make something clear. I mean, we certainly support that our mining companies engage extensively. And you really do have to engage extensively. So that's really our official position. I mean, I was involved in the Dingleton relocation probably about, I think in about 2020, was it 20? Oh, I'm trying to remember now. Sorry, it was about 6 years ago, sorry. So 6 years ago I was involved. I mean, there was extensive consultation. I mean, we had, I don't know how many town hall meetings, you know, with the community of Dingleton. We had extensive meetings with them. So that is not a classic case of the way of there being lack of consultation. That is certainly not the case. And also you're dealing also with individual title holders here. Because remember, at the end of the day, a person is not going to move and agree to sell their piece of land unless what they're getting the other side is a lot better. So the majority of the Dingleton residents have actually accepted that they are actually better off in a town like Kutu, which are with better prospects of better facilities, better road access, better jobs, than a town like Dingleton, which was essentially a town that when things changed wasn't really getting much traffic in terms of roads and wasn't getting much development. So that town was really slowly but surely dying. So the majority of Dingleton residents have actually realized that they are much better off for instance, in the town of Kutu. So that's a very different situation. But you will never, ever please all the residents. I think that's one thing that's clear.
No, clearly. Big topic. Thank you for discussing it with us, Tebelo, Johan. Blessings. Thank you. Coming up next, we look at whether authorities are doing enough to deal with what's called collective rape and protect victims.